Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today we're going to finish our discussion about record retention, and today we're going to focus specifically on the documents that have to be contained in each transaction folder. Here's a list. The documents that have to be included in a transaction folder come directly out of the Washington Administrative Code and include all agreements, receipts, contracts, documents, leases, closing statements, and material correspondence. Most of those documents are self-explanatory. All agreements, the listing agreement, the purchase and sale agreement, addenda to the purchase and sale agreement, all of those documents have to be delivered within 2 days of the date of mutual acceptance of that document. So if we're talking about a purchase and sale agreement, then you have 2 days from the date of mutual acceptance to get that document delivered to your managing broker. Now, designated brokers, you should have a firm policy in place. Every broker should know the firm policy for how documents are submitted. Brokers, it's then up to you to make timely submission of those documents. So documents that have agreement between the parties, the deadline for submitting them is within 2 days of mutual acceptance. If we're talking about an earnest money check, brokers, you have 2 days to get that earnest money check delivered to your managing broker, unless within that time frame you can instead get the earnest money check delivered to the ultimate holder of the earnest money. So for example, buyer makes an offer on a Monday, writes an earnest money check to go along with that offer. That offer is accepted on Tuesday, and the earnest money is to be held by ABC Escrow. Buyer broker, instead of delivering that earnest money to your managing broker, you are authorized to deliver that earnest money directly to ABC Escrow. Get timely, you'll have a receipt in your transaction folder showing your receipt of the earnest money from the buyer on Monday. You'll also have proof of delivery of that earnest money to the escrow company on Tuesday. But let's say, same scenario, you get the earnest money check from buyer on Monday, and by Wednesday you still don't have mutual acceptance. You and buyer and seller are going back and forth. Maybe you ultimately get mutual acceptance on Friday, but you don't have it by the end of that 2-day period following your receipt of the earnest money on Monday. That means that within those 2 days, you have to tender or deliver that earnest money to your managing broker for safekeeping. Then when you get mutual acceptance, managing broker has to get those earnest money funds over to the escrow company. You're going to have to be in communication with your managing broker to make sure that happens. What about other documents that aren't triggered by a date of mutual acceptance? What about an inspection report? That you're the buyer's broker, you get the buyer's inspection report. Within 2 days of receipt of that inspection report, you got to tender it to your managing broker. Transaction is closed, you get a settlement statement. You've got 2 days to tender that to your managing broker. Advertising is a document that has to be retained in the transaction folder because advertising is considered a material correspondence. You're communicating with the public about the property or about your services. Your advertising has to be retained in the file. How do you retain advertising? Well, if it's a print ad, it's pretty simple. You take a copy of the print and you put it in the transaction folder. If it's a radio ad, then you take a transcript of the radio ad, put that in your transaction folder. If you're advertising on a billboard, take a picture of it. If it's social media, maybe you screenshot a page. Somehow or another, you have to capture the advertising and keep a copy of that in your transaction folder. Here's the one that surprises most brokers. You have to have a copy of your material correspondence in your transaction folder. Think about all of the variety of medium that you use to communicate. Cell phone, text and voice communications, Facebook. I'm not very technologically savvy, can you tell? Snapchat, Twitter, however you communicate with your client, it has to be in a format that you can capture and print. If you can't print your text messages, then you can't have material communications with your client by text. You probably can print your emails, so you could correspond with material communications by email. However you have a material communication, you have to be able to print that communication and put it in the transaction folder, including voice communications. If you talk to somebody on the phone, it's a really good idea to then document your file with journal notes. Who'd you talk to? What was the communication? What happened? And remember, your correspondence could be with somebody other than your client. It could be with an inspector, with a broker on the other side of the transaction, with the lender, with title. There's any number of people with whom you have material communications in every transaction. You got to document those, put them in your transaction folder. How do you define material communication? Well, that is something you're going to have to define on a case-by-case basis. Safest approach, if you're not sure, retain a copy of it in your transaction file. If you're discussing something with your client that has nothing to do with the property and nothing to do with the transaction, for example, you're asking them how their dog's vet appointment turned out. Well, that's not a material communication. But if it has anything to do with the property or anything to do with the transaction, at least chances are it's a material communication, and you ought to save a copy of that for the transaction folder. Does this seem burdensome to you? Probably, because most people don't do it. The Department of Licensing has found that almost no firms retain copies of material correspondence. I started out this video series by telling you that DOL is auditing for this issue. DOL is in fact auditing firm transaction folders to verify that material correspondence is being retained in those folders. Why? Because the communications you have with your client are often the most important element of proving or refuting a claim in your favor or against you. What did you tell your client? When your client asked you a question that required a legal analysis, did you advise your client to seek the advice of legal counsel? When your buyer asked you a question that involved mold remediation, did you advise your client to seek the advice of a mold remediation expert? When your client's inspection deadline was looming, did you communicate with your client to let them know that they only had until 9 p.m. on that final day to communicate their inspection requirements to the seller? All of those are examples, obviously, of material communications and communications that should be documented in your transaction folder. And the DOL may not be the only entity you have to satisfy with this regard. If you ever find yourself in a defendant's chair in a lawsuit, your lawyer is going to want to have a complete transaction folder full of your communications, because I bet your communications are going to help you defend a lawsuit. Your communications will never help you defend a lawsuit if you haven't retained them. In fact, to the contrary, when you try to explain to a jury that you did, in fact, tell the buyer that their inspection deadline was looming, and then the buyer's lawyer goes to your transaction folder and says, well, let's see, there should be evidence of that communication in your transaction folder. And you say, no, I just told them about it, or I emailed it, but I didn't print it, and my computer's crashed, and I can't get the email. The buyer lawyer's response is going to be, well, the law requires you to retain a copy of that material communication in your file. Your file doesn't show it, and so the only obvious conclusion is that you didn't really have that communication. That would be a horrific outcome in a situation where you probably really did advise your client to be wary of the approaching deadline. Make sure you've documented your file to prove those material communications. If you have questions on this topic or any other, this is a huge issue, and it all boils down to risk avoidance. If you have questions on this topic, send an email to me, legalhotline@warealtor.com. Thank you for being a Washington Realtors member.